Welcome to the Judicial Committee of the Privy Council. Today we are hearing the appeal of Mr. Alexander Pleshakov from the decision of the Eastern Caribbean Court of Appeal in a case originating from the British Virgin Islands. The main issue in the appeal is whether the shares in the first respondent company SkyStream Corporation, which is a British Virgin Islands company, which are registered in the names of the second and third respondents, Mr. Linkoff and Ms. Kazantseva, are held by them beneficially, or as Mr. Pleshakov claims, on trust for him. The judge in the British Virgin Islands found for Mr. Pleshakov, whereas the Court of Appeal found for Mr. Linkoff and Ms. Kazantseva. The appellant, Mr. Pleshakov, appears by Mr. Robert Levy, Queen's Counsel, leading Mr. Daniel Warrants and Mr. Oliver Clifton. The second and third respondents appear by Ms. Barbara Doman, Queen's Counsel, leading Mr. A.J. Rattan and Mr. Barnaby Lowe. I am Lord Briggs. Sitting with me this morning are Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Hamblin.
Good morning.
And Lord Stevens.
Good morning.
We have found from some months' experience now that a full session staring at screens tends to be more burdensome than a face-to-face session of the same length. And therefore we habitually now take a short 5-minute break halfway through the morning. Mr. Levy, you will be on your making your submissions at that stage. So if you could choose a time as near as 11:45 as you can, that will be much appreciated. And now it remains for me to ask Mr. Levy to make your submissions.
Good morning, my lady and my lords. On that point, my lord, I'd understood that we were to take a short break at about 5 to 12, and I'll be sharing the submissions this morning with Mr. Warrants, and I was hoping, but can offer no promises, that my submissions would be finished by about 5 to 12, but should we see where we go? I'm more than happy just to add a few minutes on at the end if the board wishes to take the break at 11:45.
No, 5 to 12 will be perfectly satisfactory if that's a better breaking point in your case.
Well, let's see where we go if that's acceptable to the board.
It is.
My lady and my lords, as you'll have gathered, our case is that the respondents hold all the issued shares in SkyStream on trust for Mr. Pleshakov absolutely. At the trial, Mr. Justice Bannister found in favour of Mr. Pleshakov and made an order declaring that the respondents, and I'm just going to call Mr. Linkoff and Ms. Kazantseva the respondents. SkyStream doesn't take any part, so I'll just be referring to them as respondents. Mr. Justice Bannister made an order declaring that the respondents did indeed hold all the shares in SkyStream on trust for Mr. Pleshakov absolutely. The Court of Appeal, after, how shall I put it, a surprising 3.5-year delay between the hearing of the appeal and handing down its judgment in November, I think, 2018, overturned Mr. Justice Bannister's decision and dismissed Mr. Pleshakov's claim. My lords and my lady, in a nutshell, we say that the Court of Appeal was wrong for 3 principal reasons. First, we say that the Court of Appeal fundamentally misunderstood the basis of the judge's decision. The Court of Appeal, as you'll have seen from their judgment, focused its attention on whether there was a contract between the parties, whereas what it should have done, and as Justice Bannister did, was focus on whether there was a trust in respect of the SkyStream shares. Secondly, we say that the Court of Appeal impermissibly interfered with the trial judge's primary factual findings and evaluative decisions based on those findings. And thirdly, we submit that the Court of Appeal's own evaluation, once it had decided to overturn Justice Bannister's decision, was completely wrong, because it ignored important factual findings that had been made by Mr. Justice Bannister at trial, and that such findings were correct, or at the very least, our primary case is obviously that they were correct, but at the very least, those were findings that were clearly open to Mr. Justice Bannister as a trial judge to make. So, subject to the board's views, we intend to address the issues in the following order. First, as my lady and my lords will have gathered from the written cases, there's a disagreement between the parties about the correct use of certain terms, particularly the terms bear trust and nominee. And it seems to us that there is a danger that we may end up talking past each other because of these disagreements about terminology, rather than dealing with the substance of the matter. So I will open with a few words about terminology. What does it mean to be an absolute owner? What is a bare trust? What is a nominee? Our overarching point is that there is absolutely nothing in my learned friend's arguments on that front. The second primary point taken against us by the respondents is that this is somehow a new case which we are advancing here today for the first time, and a case that obviously wasn't advanced below, so they say. We say that is completely wrong, and to make good that point, I'm regrettably going to have to spend a little bit of time taking you through some important documents, pleadings, witness statements, etc., and skeleton arguments in the record, to show you that Mr. Pleshakov's case throughout has been that the SkyStream shares are held on trust for him, absolutely, and that he has remained constant in that throughout the entire proceedings. Thirdly, I'm going to address the learned judge's findings about events surrounding the incorporation of SkyStream up to and including the transfer of the Transaero shares to SkyStream, in order to demonstrate that these findings were properly made and fully support his ultimate conclusion that the SkyStream shares were held on trust for Mr. Pleshakov, absolutely. And that should take us to the mid-morning break, whenever that is. Fourthly, my learned junior, Mr. Warrants, is going to deal with the judge's findings about the subsequent conduct of the parties up to the commencement of these proceedings in 2013, in order to demonstrate that those findings were properly made and fully support his conclusions. And finally, Mr. Warrants is going to address you directly on the flaws in the Court of Appeal's reasoning. So, Lords, before dealing with the first point, I should say that we have set out at length, and you all have seen, the relevant authorities in paragraphs 27 to 45 of our written case about appellate courts interfering with factual and evaluative decisions made by trial judges. My lady, my lords, that was up to date as at the time of our written case, but on the 14th of this month, we had my Lord Briggs's decision, in which two other members of this panel sat in Ming and Ming. So unless it's absolutely necessary, and unless the board invites me to do so, I'm not going to say anything more about that. I think the board knows the principles all too well, and certainly for three of this panel, they are very fresh in the judicial memory. But what we do say is that when one stands back and looks at the judge's findings and the evidence in support of those findings, which I'll address in detail, this is clearly a case where those principles apply, and that the Court of Appeal erred and was, for want of a better word, in breach of those principles in reaching the conclusion that it did 3.5 years after hearing the appeal. So I'm not going to say any more about that unless I'm specifically invited to. So can we start off with a discussion about terminology? And it seems to me this is an odd tribunal, particularly with the composition of the tribunal, to give a 101 class on what is a bare trust, what is a nominee, what does it mean to be an absolute beneficial owner. But I'll take this quite briefly, and come back to it and reply if I need to. We do accept that there is no universally accepted definition of the two terms that have become controversial on this appeal, namely bare trust and nominee. You will have seen that we use those terms in a particular way, which we have explained in a footnote on the first page of our written case. And rather than take it up, I could summarize what we say. We say there that the term nominee in this context simply means the trustee of a bare trust, being a trust under which the beneficiary is absolutely and indefeasibly entitled to the whole of the beneficial interests. Now, the respondents clearly don't agree with our definition of those terms, and that's why we say that there's a danger that we can end up having a lengthy semantic debate about the use of those terms that sheds no real light on the substance of the respective parties' positions. So I'll just dedicate a few moments to this. What does it mean that an asset is held on trust absolutely for someone? And if we can start by looking at the claim form in this case, which is at bundle tab 9, page 90. I'm not sure whether it helps me calling out the tab numbers, but page 90.
Well, Mr. Levy, we're all using the electronic. So I think probably the electronic pagination is what we both need and all we need.
Okay, so page 90, my lord. And there we have the claim form. And if one looks down at paragraphs 2 and 3, we see that the relief sought against each of Mr. Linkov and Ms. Kazatseva was a declaration that the shares, 25,000 shares each of them held in SkyStream, were held on trust for Mr. Pleshakov absolutely. So that's how the relief was framed. And then if you go back to take...
Mr. Levy, just before you go on, could I, on reflection, just check with Ms. Doman that if Mr. Levy simply uses electronic page numbers, that won't cause you or your team any inconvenience?
Grateful. I'm very grateful, my lord, and no, it does not. Thank you.
Thank you very much. Do carry on, Mr. Levy.
So I think I'm the only one working from a hard copy bundle. There we are. If we can go back then to page 19 of the bundle. That is the order and declaration that Justice Bannister made. And again, paragraphs 1 and 2 reflect the relief sought in the claim form. He declared that each of the respondents held their shares on trust for Mr. Pleshakov absolutely. So the question then becomes, what does it really mean that one person holds an asset on trust for another absolutely? And we say that inherent in that concept, and I'll make this good, are three things. First, that the beneficiary has a present vested beneficial entitlement to the whole of the trust property. Second, that that entitlement is not subject to any contingency such as attaining a particular age or the happening of an event. And third, that the beneficiary's entitlement to the trust property is indefeasible. That's to say that it can't be diminished, defeated, or diluted without the beneficiary's consent. Now, we have said in our written case that the terms bare trust and nominee can properly be used as synonyms to accurately describe a situation where a trustee holds on trust for a beneficiary absolutely. And we say that that terminology is entirely appropriate for this purpose. And we point to an article by Professors Thomas and Hudson in their book, The Law of Trusts, which is at page 4406, which is conveniently, I think, the last page of the document. So we started at the beginning and we've now reached the end. Unfortunately, it's not over yet. And if, my lady, my lords, have that page, we see there that the professors say that a bare trust arises where the trustee holds property on trust for a single or several absolutely entitled beneficiary. The beneficiary therefore holds the entire equitable interest in the trust fund. Consequently, the trustee has no discretion nor any obligation other than the stewardship of the trust property on behalf of that beneficiary. The beneficiary herself must not be subject to any contingency or encumbrance which will interfere with her equitable interest in the property. She will hold the entirety of the possible equitable interest in that property. The trustee in such a situation is generally referred to as a nominee. So we say we are in good company, as was Justice Bannister, in using the term bare trust and nominee interchangeably. That is one who holds a property in the name of another. Further to the principle in Saunders of Vautier, the beneficiary is able to direct the trustees how to deal with the property, even if the trust instrument purports to direct the trustee to hold the property in a manner which is contrary to the beneficiary's wishes. So that's what Hodson and Thomas say about bare trusts and nominees. I should also say that the respondents actually used the term bare trust to describe the position found by the judge in their skeleton argument for the Court of Appeal. So if we go to page 344, at paragraph 33, you'll see that it was said there, the finding that Mr. Linkoff had borne these costs is wholly at odds with the case of Pleshakov, that he was the beneficial owner of Skystream. So too is the fact that Kazan Sabre reimbursed Mr. Linkoff for her half of the cost. There will be no reason for bare trustees to bear such expenditure themselves, so on and so forth. So we can hardly be blamed. Not only are we in good academic company, but we can hardly be blamed for using those terms interchangeably, because it's an expression that was adopted by the respondents. Now, my lady, my lords, we say that it is clear that the sense in which I've just defined the term nominee is exactly the sense in which Justice Bannister used the word nominee in his judgment, because he consistently used the term nominee interchangeably with trust, and ultimately to mean holding on trust for Mr. Pleshakov, absolutely. So to make that good, if we can go to page 3, paragraph 7 of the first instance judgment. If we're there, we see this. Mr. Pleshakov pleads that in late 2005, Linkoff advised him that if he, Pleshakov, were to acquire a holding in Transaero exceeding 50%, he would become obliged to offer to buy out the remaining shareholders, but that this obligation could be avoided if part of that shareholding to be acquired for the BB Group were to be held by a newly formed company whose shares were held by nominees for Mr. Pleshakov. And then in paragraph 8, the learned judge says this 3 lines down. Mr. Pleshakov pleads that the defendants travelled to the BVI in December 2005, and while there signed a deed of trust dated 28th of December 2005, evidencing a trust over the Skystream shares in Mr. Pleshakov's favour. Now, I'll come back to the deed of trust and what it did or didn't do. But the judge's understanding was that the deed of trust, and we don't say that the deed of trust created a trust. That's not our case, and it's never been our case. But the judge there explains that the deed of trust evidenced a trust. And then if we move on to paragraph 52 of the judgment, the discussion on page 13. Line 3. The sole question in this case is whether the defendants acquired SkyStream pursuant to an arrangement. In other words, note the words arrangement there, not agreement or contract, but arrangement with Mr. Pleshakov that they should do so as his nominees. And then at paragraph 62, in my judgment, the evidence establishes that the defendants acquired the SkyStream shares as nominees for Mr. Pleshakov. Nothing that happened subsequent to that acquisition is inconsistent with that finding. Indeed, I find it fully harmonises with it. It was suggested that the manner in which the shares belonging to himself or to members of his family were dealt with was inconsistent with any suggestion that the defendants held their shares as nominees for Mr. Pleshakov. And then, in particular, it was submitted that if Pleshakov was, as I have found, the beneficial owner of SkyStream.
Could I ask a question? At this point, I'm not sure, Mr. Levy, if you're looking at the court or whether you're looking into the bundle on your screen, because you seem to be facing a different direction. But could I just ask the question? You took us to the definition on page 4406 provided by Thomas. And line 1 is very important, isn't it? A bare trust arises where the trust...
Stay with me, my lady, sorry.
4406.
Yeah.
Para 1.27. Line 1 is particularly important, isn't it? A bare trust arises where the trustees hold property. So what we're looking at is why they are holding the property, the circumstances of that relationship.
Yes.
With the property. Now, it could arise in 100 different ways. It could arise by statute law, it could arise by contract, it could arise by custom, it could be lots of things. But what we're focusing on is that relationship. Why are they the registered holders of the shares? They, the respondents. Why are the respondents the registered holders of the shares?
Yes.
That's the critical question.
That's the critical question, and that's a question that the judge, the learned judge, addressed. He said the important thing was to, well, I'll take the board to our pleading, but it goes to the question of for whose benefit was SkyStream incorporated? And that's really the question that Justice Bannister, quite rightly in our submission, addressed.
Well, that's one of the questions, and it may throw light on the ultimate question of why are they holding the shares.
Yes. Does that assist, my lady?
It does, but I thought you went over Thomas rather quickly.
I'm sorry. I'm sorry. I've got a lot of ground. I've got a lot of ground to cover.
All right. I'm also not sure that you can see us, but there we are.
I can see you. It's just a setup. I'm not sure the board's particularly interested in my technological challenges, but so long as you can see a bit of me and hear all of me, I apologise if I'm looking in the wrong direction or anything else. Just going back to the judgment, paragraph 62, we have Mr. Justice Bannister using the terms interchangeably, nominee and beneficial owner. And what was the conclusion that he reached? Well, we've already seen the declarations that he made, and the declarations were that they were that Pleshakov was the absolute beneficial owner of those shares. Now, to be fair to the respondents, although we suggest it's absolutely clear that Justice Bannister used the term nominee in the same way that we do, and the same way that Professors Thomas and Hudson do, we do accept that it's not a universally accepted definition of the term nominee and bear trust. And we suggest that the best way to avoid this confusion is to jettison terms such as nominee and bear trust, and simply refer to the holding of shares on trust for Mr. Pleshakov absolutely. I will touch very briefly, but I really think there's very little, if any, well, I think there's nothing in the point. I'll touch very, very briefly on the way the point is raised and argued by my learned friends, and I may come back to his reply if I need to. The source of their argument on nominee and bear trust is an article written by Professor Paul Matthews, now His Honour Judge Matthews, and they refer to that in footnote 30 on page 19 of their case. I'm not going to go to that article now. I'm sure it's a very learned article, but I don't think the board will gain a great deal from entering into a debate as to whether Professor Matthews, His Honour Judge Matthews, would have used the language in the same way that Justice Bannister did, or that Mr. Malshenson did, or whoever drafted the pleading did. That's really not to the point. The issue raised by Professor Matthews' article can be shortly stated. He distinguishes from what he called, he distinguishes a bear trust in the sense of a Saunders and Vautier type trust from what he calls a bear trust plus agency type agreement. And in that situation, there is a bear trust and a contract by which the trustee agrees to do anything that the beneficiary may ask. And he says that that is commonly called a nomineeship. And that's a distinction that my learned friends have fixed upon. Now, I dare say you'll be taken to it in due course. When you are, do look out for footnote 12 to Professor Matthews' piece, because he freely accepts that not everyone agrees with his categorization. And amongst the dissenting views are, as recorded in footnote 12, are Professor Hayton, who, with great respect to him, knows a thing or two about trusts, and Professors Thomas and Hudson. But we say this is an entirely semantic debate and thoroughly unremoved from commercial life. Let's assume that that A conveys property to trust, to B rather, to be held on the terms of a quote unquote fair trust. A then says to B, can you do X with that property? And let's assume that X is not convey the property to me or someone else. B that does it, or he says, no, I'm a bare trustee, I'm not going to do that. In which case A then removes him, whether by injunction or whatever else. But it's an entirely arid debate in commercial terms. So that is the terminological, if I can put it that, if that is a word, debate between us. We say there's nothing in it. We say we are on solid ground in defining, in using the terms bare trustee, bare trust, and nominee, nomineeship interchangeably. That's what the judge did. We're in good company. I'm not suggesting Professor Matthews isn't good company, but it's at best an intellectual debate and not a practical debate. So that's all I want to say about terminology. The next point I want to deal with is the suggestion that that we somehow advanced a new case below. We are advancing a new case now, and that case differed from our case below. Our position is that we have been consistent from the very outset of the proceedings, and that a fundamental aspect of our case is establishing that the shares in Skystream are held on trust for Pleshakov. Absolutely, nothing here is new. The point is raised in paragraph 3 of my learned friend's case. We say that they are wrong. In order to do that, I'm going to have to say, as I suggested earlier, I'm going to have to take you to some passages in the pleadings. Well, I'm going to start with it. I'm going to start with the statement of claim. But sorry,
just so you know, Mr. Levy, we do have your new case memorandum.
Yes.
And we have also recently received the respondents, what you might call counter memorandum, in other words, the annotated version of your memorandum.
I'm more than happy. It dawned on me yesterday that rather than actually invite the board to go to trawl through pages of the electronic bundle, it might be helpful to have one document. I'm more than happy with the amendments in red that my learned friends made this morning, and I apologise to everyone if it was a bit late. It's only when one's preparing the day before that one realises there may be a quicker way of doing things. My Lord, I will go to that very briefly if necessary, and I will go, in fact, to the statement of claim in the record itself. But before we go there, I just want to, and again, it's a bizarre tribunal to be making these points too, but I just want to make a number of points about the elements necessary to create a trust. And they're obviously very well known to my lady and my lords. We all remember the 3 certainties: certainty of intention to create a trust, certainty of the subject matter, and certainty of the objects, i.e. who are the beneficiaries. And in this case, there's never been any doubt that if there is a trust, then the subject matter is the shares in Skystream, and the sole beneficiary is Mr. Pleshakov. So the real dispute is about establishing whether the respondents intended to hold the Skystream shares on trust for Pleshakov. Now, we say crucially, none of that, and I think this is, and I can refer back to my Lady Arden's observations earlier, none of that relies on a contract. A trust can arise in any number of ways. I don't think there's any dispute between us that there is no need for a formal declaration of trust. A trust can be created by an oral declaration or inferred from conduct. And we refer to a passage in Snell, but I really don't think we need to look at it to make good that point. And then in paragraph 24 of our case, I don't think we need to take it up. We refer to a dictum in Reed Hayford by Mr. Justice McGarry, where he said the question is whether in substance a sufficient interest to create a trust has been manifested. Now, the respondents say that that case wasn't cited at first instance, and so, that proves that this must be a new case. Well, my lady and my lords, that we say is, with respect, a thoroughly bad point. Justice Bannister was an extremely experienced judge in the commercial court in the Virgin Islands. Before that, I think it's fair to say that he was a very well-respected chancery practitioner in London, and he knew what a trust is, and he knew how trusts are created. I mean, they want to say, by contrast, this is a contract case. Well, where are all the authorities in the submissions about offer and acceptance and consideration? That's a non-point. So, if we could go to page 94 of the bundle and look at the statement of claim. Paragraphs 1 to 3 are really just by way of background, and in paragraph 4 we get Mr. Pleshakov's involvement in negotiations in 2005 to acquire a substantial stake in Transaero from the Berezovsky group. And then in paragraph 5, in its subparagraph, it's pleaded that Pleshakov and Linkov had meetings in late 2005, at which Mr. Linkov advised Pleshakov that if he acquired the Berezovsky group's shares in his own name, he would have to make an offer to buy out the Transaero, other shareholders in Transaero. And then it said that he was advised, Pleshakov was advised, that this obligation could be avoided if the shares being acquired from the BB group were held by a new company whose shares were in turn held on Mr. Pleshakov's behalf but not registered in his name. And then we get Mr. Linkov's suggestion that if Mr. Pleshakov asked him, Mr. Linkov would incorporate such a company and, together with Ms. Kazantseva, hold the shares in that new company on his behalf. Then in paragraph 6, this is the paragraph in which this huge controversy arises. We accept that there was a plea, that there was a contract between Mr. Pleshakov for the respondents and the respondents, that the respondents would act as nominee shareholders and directors of each of the new company in return for a particular salary. And we accept that Justice Bannister didn't make any express finding in relation to that. But we say that it wasn't necessary for him to have done so, and certainly that his failure to make any finding in relation to that does not mean that our case should fail. And then in paragraph 7, in terms of the creation of the trust, you get the most important part of the pleading. And this again goes back to my Lady Ardern's point. On the claimant's instructions, the second defendant caused the company to be incorporated. And it goes on to refer to the deed of trust. The claimant's instructions, the second defendant caused the company to be incorporated. On the same day, the company issued shares to be held in the name of the second defendant on behalf of the claimant, and shares in the name of the third defendant on behalf of the claimant. And then in paragraph 8, we have reference to the deed of trust that was executed. We'll look at that a bit later. And it said that the deed of trust evidenced the trust over the shares in the claimant's favour. Now, this is essentially the part of the pleaded case that Justice Bannister accepted, and that we continue to rely on today in order to support his judgment. The facts pleaded at paragraphs 7 and 8, once established, satisfy the three certainties. The subject matter of the trust is the issued shares in SkyStream. Beneficiary is Pleshakov, because it's pleaded that the shares are held on his behalf. And the intention is pleaded in the first sentence of para 7, where it says that the steps were taken on Mr. Pleshakov's instructions for the purposes of avoiding the obligation to offer to buy out. And then in paragraph 8, not strictly necessary for pleading purposes, you get the plea that the trust over the shares is evidenced, not created by, but evidenced by the fact of the production of the deed of trust, and we'll look at that later. And then on page 9 of the pleading, so just bear with me, sorry. Then paragraph 9 of the pleading, we have the plea that the deed of trust was provided to Mr. Pleshakov together with the share certificates. Again, That was essentially accepted by the judge, although the judge found that the documents were sent by post rather than handed over in person. We say nothing ultimately turns on that. And a controversy on an issue such as that, in evidence 9 years or 8 years after the events in question, is really not of central importance in a case of this nature. And then for your notes on the last page of the pleading, paragraphs 2 and 3 of the prayer, we see the prayer which replicates the prayer for relief in the claim form that we looked at a little earlier. So that's the statement of claim and how it was put. If we could now take up, my learned friends, or the agreed aid memoir with everyone's comments on it, and turn to paragraph 4, which I got on page 2. I haven't looked at a hard copy, I'm afraid. And we're here taking a number of documents from the record to show what our case was throughout. And so in paragraph 4 of the note paragraph numbering, there's a reference to Mr. Pleshakov's trial witness statement. And we had emphasised in black, bold, underline, italics, hold all the shares in the company on trust for me, absolutely, and have done so since December 2005. We say that nothing in the words that Ms. Doman and her team have added in red really changed that position. A bare trustee, even in Matthew's sense 1, may not be obliged to do what is told. He may, if asked to vote shares in a particular way, he may well be entitled, as a matter of law, according to Professor Matthews, to say, no, that's not my job. But that's not a practical situation. He either does it or is fired. That's a practical reality. So nothing that's been added here in red assists my learned friend. And then the second quotation from the appellant's trial witness statement, again, refers to the shares held by them on trust for me, absolutely. This was a trust case. And then underneath that, in the citation of paragraph 57. And the shares were issued to them to hold on trust for me. This is not a new case. And then in paragraph 6 of the aid memoir, there's a reference to Mr. Pleshakov's trial skeleton. Paragraph 1, Mr. Malshenson said this: Mr. Pleshakov seeks declarations that the shares currently registered in the name of Messrs. Linkov and Kazantseva are held on trust for him, and a declaration accordingly. And then in paragraph 7 of the aid, the issue can be shortly stated. It's whether the individual defendants hold the shares as trustees or nominees for Pleshakov. And then I got it over the page, paragraph 8, where Mr. Malshenson said this: the only rational explanation for Linkov giving the deed of trust, the share certificates, the seal and other company documents to Pleshakov was that, as he informed Pleshakov, the individual defendants held the shares as trustees or nominee for him. No mere agent of the company would need to hold certificates to the shares. Mr. Linkov at that time perhaps was acting perfectly properly, was trying to show Pleshakov that the company was his and he controlled it. So the words that my learned friend has asked to be added actually help us, support us. Again, paragraph 9, as trustees, nominees of Mr. Pleshakov. And then again in the trial skeleton argument, contending that the shares were held by D2, D3 on trust for him. Again, the reference in paragraph 4. And this is Mr. Linkov's skeleton argument. This is what Mr. Linkov understood the case to be about. Held on trust for him. They deny it. And then paragraph 11, the primary issue in this case is whether the shares are held on trust for C. And then my learned friends added paragraph 8, Thus, this is a case where there is no dispute as regards the defendants being the registered shareholders, but where seeks to assert a beneficial interest. Again, all these roads lead to Rome. All these pointers, we suggest, go in the same direction, and so on and so forth in that document. And I'm not sure that my learned friend has. And so over the page, we refer to how the case was put in cross-examination. Again, it was fairly put to the witnesses that this was about trust or absolute beneficial ownership or absolute ownership. I'm not sure I need to go to those specific statements. And then in the trial judgment, this is paragraph 26, we've already looked at that, evidencing a trust. And the passages we've looked at in paragraphs 56 and 62. And then in paragraph 32, there's a reference that we looked at earlier to the skeleton argument before the Court of Appeal, where it was Mr. Linkoff and Mr. Cassatt-Saver's skeleton argument, where they refer in paragraph 33 to a bare trust, and so on and so forth. And then if we go to the oral submission, so this is paragraph 35 onwards. Mr. Freedman, now Mr. Justice Freedman, said, we just find that the judge comes to the view that there would have been a trusteeship. And then Mr. Malshanson, underneath that, paragraph 36, the issue the judge had to decide really was there an oral agreement, arrangement or agreement? It doesn't really matter in this context because we're dealing with proprietary rights here. And we say the agreement was that Mr. Linkoff, Pleshakov, is quite clear about this. He spoke to Mr. Linkoff and the agreement was made that a company would be formed, which became SkyStream, and the shares in that company would be held for Pleshakov, and that SkyStream would acquire the shares in Transaero. But the important point there is that when one's dealing with proprietary rights, it doesn't really matter whether there's a contract. What happens if the contract fails and valuable assets are handed over? Can the quote-unquote trustee then just say, well, homie, I got the shares, contract fails, and I'm now £20 million the better off for it? And Mr. Malshanson, in the text in paragraph 37, made a similar point about a property interest. And he said this, so Mr. Linkoff, if you like, roped in Cassatt-Saver into this arrangement, and we're dealing with property interest here. And what you can't do is simply say, well, I didn't make any agreement. She must have known about this because she signed that extraordinary document. That's a reference to the trustee. She was well aware that these shares were held on trust. And then finally, over in the last quotation from Mr. Malshanson's submissions. And true enough, he referred to the fact that there was a discussion about payment. Of course, you'll have seen the judge found that these people were in fact paid and paid handsomely. And then he says this at the end: if consideration is needed, once they'd agreed to hold shares on trust, actually that was really an end of it. So even if they've agreed to hold the shares on trust, even if there was meant to be a contract and the contract wasn't found, it's a proprietary claim, and that's an end of it. So that's the aid memoir. So far as the position before the board is concerned, we say that the point is fairly raised in paragraph 4 of our grounds, of appeal, which is at page 2245. And you'll see there that we said the Court of Appeal erred in focusing upon particular aspects of the factual matrix, in particular the oral agreement, as being determinative of the case as a whole. In doing so, the court engaged in a telescopic or perhaps microscopic analysis rather than focusing, as it should have done, on the totality of the evidence. Had it done so, it would have concluded that there was no basis for interfering with the judge's conclusion, much less reversing it. So, my lords, you'll have read the documents in any event, but we suggest that the assertion that we are somehow running a new case before the board is simply not borne out by the documents referred to in the aid memoir. And so I don't propose, unless I'm specifically invited to address the authorities on raising a new case on appeal. We say the case as put in the Court of Appeal, well, as put in evidence, as in the judgment, as in the Court of Appeal, and before the board, has remained consistent. This is a case about a trust. True enough, a contract was pleaded. True enough, the judge didn't find that there was a contract, but that was a separate point, and it wasn't necessary for the learned judge to have found that that particular contract was entered into in order to stamp the respondents as trustees in favour of Mr. Pleshakov, or as nominees, I don't shrink from that, in favour of Mr. Pleshakov of the SkyStream shares. So that's a second limb of my submissions. And what I'd like to do now is address the judge's findings concerning events around the time of incorporation and up to and including the transfer of the Transaero shares into SkyStream. And what I'm addressing now is really paragraphs 46 to 125 of our written case. The relevant background to all of this is the battle for control of Transaero between Mr. Pleshakov and Mr. Berezovsky, or their respective groups of interests, dating back to 1998 or thereabouts. It has never seriously been disputed that control of Transaero was very important to Mr. Pleshakov. And you will have seen that the judge held at paragraph 2 of his judgment that, and I quote, since at any rate 2005, Mr. Pleshakov has had one of his aims, the achievement of direct or indirect shareholder control of Transaero. That finding has never been challenged or put in doubt. Nor has it ever been disputed that if Mr. Pleshakov was indeed the ultimate beneficial owner of SkyStream, then once a 19.9%, and I'm going to call it 20%, but the actual figure is 19.9%, once a 20% stake in Transaero had been transferred to SkyStream, Mr. Pleshakov would have owned directly or indirectly, a majority of Transaero shares. His case was that he owned 40-odd%, and that as a result of his dealings with the Berezovsky interests, further 20% was acquired. Well, greater than that, in fact, we're only concerned with this 20%. It's also common ground that the respondents had no role in negotiating the acquisition of that 20% stake in Transaero. They were involved, I think it suggested that Mr. Linkov was involved with a bond issue in Transaero Finance, something of that nature, but not in relation to the acquisition of the 20% stake from the Berezovsky group. Mr. Pleshakov dealt with that process without any involvement from the respondents. Mr. Linkov admitted at trial that until he saw the Housecroft share purchase agreement, and my lady and my lords will remember that that is the agreement by which SkyStream acquired its Transaero shares, until he saw that agreement, which was executed at the end of March 2006, so some more than 3 months after the incorporation of SkyStream. He didn't even know what price SkyStream would have to pay for the Transaero shares. So that's the context in which these transactions from December 2005 took place. And the point is this: would Pleshakov, a Russian businessman, although his Russianness has nothing to do with it, really have arranged for a 20% stake, which would have given him control when added to his prior interest? Would he really have arranged for that stake to go to a company owned by the respondents beneficially, even though it would have deprived him of the opportunity to acquire or to obtain a majority shareholding in Transaero, something which, according to Justice Bannister and a finding which hasn't been challenged, had been one of his objects since, at the latest, 2005. Would he honestly, would he have done that? And would he have done it for $55,000? Mr. Warrants, I think, is going to have a bit more to say about value in his submissions. We say that it's simply implausible that he would have simply given away that opportunity, and much more implausible that he would have given it away for a bowl of pottage, $55,000. Now, the only explanation the respondents have ever been able to give as to why Pleshakov would have done this is that they were being paid for legal work, or repaid rather, for legal work they'd previously done for Transaero, for which they had not been previously paid. But the judge didn't accept that evidence, and it's not a case which was pursued in the Court of Appeal or in the respondent's written case before the board. Moreover, as the judge noted in paragraph 13 of his judgment, that factual case, i.e. delayed remuneration for work we did for Transaero and weren't actually paid for at the time, has never been pleaded. In point of fact, they never actually pleaded in their defence that they were the beneficial owners of SkyStream. So the starting point and the background against which one has to look at these transactions is, and the background against which the judge looked at these transactions, is the complete absence of any rational explanation as to why Pleshakov would have arranged for a 20% stake in Transaero to be transferred to the respondents, or to SkyStream rather, if SkyStream was beneficially owned by the respondents. Now, it's all very well and good for them to say, well, we've got to prove our case. I don't suggest that the burden of proof has been shifted, but the absence of a plausible explanation as to why Pleshakov would have acted in this way is clearly a relevant factor, which the judge was fully entitled to and did take into account in evaluating the overall evidence. Needless to say, and Mr. Warrants will deal with this, the Court of Appeal completely ignored the point and didn't address it in its judgment. So now I want to turn to the plan to incorporate SkyStream for Mr. Pleshakov's benefit. It's important in this regard to note that while SkyStream was incorporated on the 14th of December 2005, everyone agrees that Pleshakov spoke to Mr. Linkov before that happened. Nobody has ever suggested that the respondents incorporated SkyStream without ever having mentioned that possibility to Mr. Pleshakov before doing so. And they couldn't realistically have done so because there's contemporaneous email communication showing that there'd been pre-incorporation discussions between Pleshakov and Mr. Linkov. Now, the Court of Appeal was very taken with the idea that the judge hadn't made any findings about when or where these discussions between the parties had occurred. And we've made clear that the trial judge, didn't make any express findings about these matters because he didn't have to. But the actual conflict of evidence before the judge was whether the two men spoke in person at a physical meeting. I think it was suggested in Moscow by Mr. Pleshakov, or whether instead they spoke about it in a telephone call when the respondents were in Antigua. Now, that being the actual ambit of the controversy, my lady, my lords, can see why the trial judge didn't consider it to be of central importance to decide exactly when and where those conversations occurred, more than 8 years or so around before trial. Now, it's also common ground that in the course of that pre-incorporation discussion, Mr. Pleshakov told Mr. Linkov that there was an opportunity to acquire some shares in Transaero, and that Linkov was the one who suggested that the shares could be held by a newly incorporated BVI company. This is another oddity about the case. Mr. Linkov accepted that he didn't know how many shares in Transaero were available, when they'd be available, or what purchase price would be payable. The learned judge dealt with this in paragraphs 15 and 53 of his judgment, where he also rejected Mr. Linkov's rather odd explanation that he didn't ask Pleshakov in his pre-incorporation conversation how many shares were on offer. And the reason being because SkyStream hadn't yet been incorporated. So it's not a case where it's not as if either party was suggesting that SkyStream was incorporated entirely unprompted by anything Pleshakov said or did. What was really an issue, as the judge correctly recognized, was whether SkyStream was being incorporated for Pleshakov's benefit, and therefore the shares were and are held on trust for him, or whether the respondents were doing it for their benefit. Now, the first contemporaneous document that sheds any light on that question is Mr. Linkov's email to Miss Simonova, which is at page 1410, 1410. And that's an email that Mr. Linkov sent to Miss Simonova for my Lord's note in her witness statement, and the judge accepted her evidence at trial. She was a secretary to the board of directors of Transaero and a general director of Transaero Finance. And she worked closely with Mr. Pleshakov. And this is an email which Mr. Linkov sent on the 20th of December to Ms. Simonova. And if we drop down 4 lines from the bottom of the kind of main paragraph there, does the board see, as for us, everything is proceeding according to plan. AP shall be informed that the name of our new partner is SkyStream Corp. Documents required for oral should be made ready by Friday. If you have any instructions for me, please send it by email. Phone connection is still unavailable since it's a total hold here. Kind regards, your attorney. Perhaps slightly unkind about the Virgin Islands, which is perhaps one of those beautiful places on God's earth. But there you have it. Everything's proceeding according to plan, and the name of our new partner is Skystream and signed off your attorney. Now, the point that the learned judge made about this email is at the end of paragraph 17 of his judgment. Having heard the evidence, having heard Linkov, having heard Simonova, the learned judge held that the most natural reading of that email is that by incorporating Skystream, the respondents were assisting Pleshakov in some plan of his, for his benefit, in other words. And we say it is highly significant and very important when one comes to look at cases, the last of which is Ming and Ming, but there's a litany of others that preceded. The judge's interpretation of what Linkov meant in that email was informed by his assessment of Linkov in the box as a witness in trial when asked questions about it. And the judge found that his response was defensive. Now, I don't propose to take the board to it. For the board's notes, the cross-examination can be found at pages 836 to 9 of the record. But the point is this, that this is exactly the kind of assessment which trial judges make day in, day out. And an appellate court, Ming and other cases, cannot really ever interfere with. The judge also considered the relevance of the respondent's physical trip to the Caribbean. On that point, I should say, and this seems to have been quite exciting for the Court of Appeal, I should say it was never part of our pleaded case that Pleshakov asked the respondents physically to go to the BVI. But we accept that in his trial witness statement, Mr. Pleshakov said that he sent them. And I also accept that the judge rejected that evidence. But the judge rejected loads of evidence in this case from both sides. The judge rejected Mr. Linkov's assertions that he had never received cash payments from Mr. Pleshakov. For your notes, paragraphs 49 and 50 of the judgment. He rejected Ms. Kazantseva's evidence that she or Linkov had ever refused to carry out a transaction with Transaero shares, as Pleshakov had instructed them. For your notes, paragraph 26. He rejected Linkov's evidence concerning the flat in Miami. Again, for your notes, paragraph 34. And he rejected Linkov's assertion of forgery. Very serious allegation to make, paragraph 39. Now, the Court of Appeal seemed to think that it was very important whether or not Pleshakov had sent Mr. Linkov and Ms. Kazantseva to the Caribbean. But they completely ignored the learned judge's analysis of paragraph 14 of the judgment. And I quote, the judge said that there was no need for anyone to travel to the BVI in order to acquire a BVI company. We say that's obviously true. A BVI company could have been formed in 2005, and I was called to the bar in the BVI in 2003. A BVI company could easily have been incorporated remotely. The BVI had telephones, it had fax machines, it had email. It was a leading offshore financial centre. It wouldn't have been very hard to have got in touch with an incorporation agent and say, I want a BVI company, or any other company for that matter, without actually having to set foot in Tortola. So the judge quite rightly made the point, and this is paragraph 53 of the judgment, that it's a rather odd thing for the respondents, no matter who sent them there. It's an odd thing for the respondents to have broken off from their pre-booked sailing holiday in this tropical paradise to take the time and trouble and expense to incorporate a company to hold shares in Transaero at a time when they didn't know when the shares would be available. They didn't know how many shares were or might be available. And most important, now this is the point that strikes me, but others may find other oddities in it, not knowing what the price would be. If all of this, if the incorporation had been for the respondents' benefit, they could have just carried on sailing merrily around the Caribbean. What their conduct actually shows is that the respondents weren't incorporating SkyStream for their benefit. They were doing it for Pleshakov's purposes, the plan, as per Mr. Linkov's email. And that's the conclusion the judge draws about these events. We say entirely properly at paragraph 54 of the judgment. And what you see, and I'm not going to go there because I know the board has read the judgment, but what we see from paragraphs 53 and 54 of the judgment is that the judge is entirely properly testing the respondents' evidence as to their intentions concerning incorporation against his factual findings and the contemporaneous documents. And he then evaluates that evidence and was fully entitled to conclude that the SkyStream was being incorporated by the respondents for Pleshakov's benefit and not for theirs. And what the judge is really doing in paragraphs 53 and 54 of the judgment is accepting paragraph 7 of the statement of claim that we looked at a little while ago, that SkyStream was incorporated on Pleshakov's instructions. And at its heart, that's all that we needed to establish in order to obtain relief, because that's an entirely sufficient basis for declaring that the respondents hold SkyStream, or the shares in SkyStream rather, for us, for Mr. Pleshakov. And the reality is that the Court of Appeal entirely missed the point of the cogent analysis that the judge subjected the entirety of the evidence to, and instead microscopically focused on whether there was an oral contractual agreement and whether Pleshakov sent them there. And the only other point they can really make about incorporation of SkyStream is that, as the judge found, Kazantsev paid the incorporation costs of around $1,000 out of pockets, and the court out of her own pocket. And the Court of Appeal was obviously much impressed by this and said, ergo, Kazantsev owns, or Kazantsev and Linkov own SkyStream. We say that argument's obviously wrong. When you're trying to work out whether a person intended to create a trust, you can't just take one element of the factual matrix and elevate it above every other fact. Now, normally, of course, if a person pays for something, then in the ordinary course, one would expect it to be theirs, i.e. that they own it. But as the judge said, this was a relatively minor out-of-pocket expense and part of a much more valuable transaction. And there was a good deal of evidence that the respondents intended to hold the SkyStream shares on trust for Pleshakov. What's more, as a judge found, and this is a point which hasn't been appealed, the judge found, having heard the evidence, having heard Simonova, whose evidence he obviously liked and accepted, and Linkov's denial, the judge held at paragraph 60 that there was a much more complicated financial relationship between Pleshakov and the respondents, which went obviously beyond these relatively small out-of-pocket expenses. and you'll have seen the fact that the judge found, as fact, not appealed, that Linkov received cash-filled envelopes. And that is following an assessment at trial, cross-examination, and no appellate court should really interfere with that finding. So, my lord, that's the background and something about incorporation. Now, the trust deed, if I may, and I'll take this as quickly as I can. We don't say that the trust deed created a trust. And so we don't have to construe the trust to see what the terms of the trust were in order to give effect to it. What we do say, and the judge found, and that Mr. Malchenson submitted, and the Court of Appeal entirely rejects, was this trust deed was an important document. Why does this trust deed exist? What does it tell us about the beneficial ownership of SkyStream? Why did Linkov cause this document to be created whilst he was on a sailing holiday in the BVI? Why did he send it to Pleshakov? So if we can look at the trust deed itself, page 1414. We find it's a nicely, well, it's a poor copy, but I imagine the original looks very nice with a bit of gold here and there, maybe a bit of ribbon somewhere. We see 1414 halfway down the page on the right-hand side, dated the 28th of December 2005. And at the foot of the page, it's referenced SkyStream Corporation Deed of Trust. If you see that under the stamp and signature of the Deputy Governor. And then over the page is a notarial certificate. Again, under the certification at the top, we see the date 28th December, and it's signed by Ms. Blake, the registered agent on behalf of the Commonwealth Trust. The meat of the document starts on 1416. The name is blocked out, but it obviously relates to SkyStream because we see that the parties are Linkov and Kazantseva as settlors and Pleshakov as trustee. And then dropping down to paragraph 1.
Isn't the important point recital A?
Sorry?
Isn't the important point recital A?
Yes.
That has been transferred to and delivered to the trustee, Mr. Pleshakov, or otherwise placed under his control the property specified in the second schedule, which are the SkyStream shares.
It's a difficult one to say, SkyStream shares, but yes. And I was going to take my lady to the schedule to make that point good, but my lady's quite right.
But this is talking about an ancillary trust to that proposed to be created by the deed of trust, or an ancillary arrangement, let's put it that way, whereby there is a vesting in the trustee of the trust property to be held under the trustee's control.
Yes.
That's a separate vesting from the vesting proposed by the deed of trust.
Quite possibly. But lady, I'm not sure that point was a point that was considered or investigated in the below or in the Court of Appeal.
There's question of law.
Sorry?
Question of law.
Question of law. But we don't have to determine, in my respectful submission, what is the effect of this document? What is the legal effect of this document? What we've got to do is say, is ask the question and answer it and come up with a plausible answer for it. Why does this document exist in the first place? There may be a nice question arising out of recital A. We say it doesn't really matter. What is the purpose? Why was this document created? And that's the point that the learned judge addressed, we say quite correctly. So we were looking at the definitions. And we see from 1A Roman 1, the trust function meaning the property, shall include the property specified in the second schedule. We'll look at that in a second. And then importantly, in B at the bottom of the page, the trust period. So it's the earlier of 50 years or such date as Pleshakov should determine. Just bear that point in mind when we come to consider some of the arguments that have been made in relation to this document. And then on the following page, the beneficiaries are Schedule 3, third schedule, and that's blank. But rather like when an equitable mortgage is created by handing over a share transfer form executed in blank, you could just stick in anyone. So Pleshakov could have stuck in Pleshakov. No reason why he couldn't have done that. And C Roman 2. And sorry, there's also a class, the ability in clause 3, to exclude beneficiaries. And Pleshakov had the power to exclude people. And then on the following page, there's a power of appointment. If you read that, and I'm not sure it's really necessary to do so, it is a very widely drawn power of appointment, which enables Pleshakov, qua trustee, to appoint the trust fund for the benefit of any beneficiary using his absolute discretion. So we say that it really begins to look like a general power of appointment, which we also say is really synonymous with absolute beneficial ownership. The proper law of that trust is page 22, is clause 22A on page 1424. I'm not sure we need to look at it, it's BVI law. But if we are on that page, do note that the document was signed by the settlors. I think the signature on the left at the bottom of the page is Mr. Well, I'm not sure which is which, but we see these signatures repeatedly throughout the bundles. So that's that. And then if you go forward to page 1436, unfortunately, the copy hasn't survived terribly well. But you should be able to discern the second schedule, the trust fund. And I think we can just about make out that the fund is share certificates 1 and 2, representing 50,000 shares in SkyStream. And then over the page 1437, again, that page signed by both the settlors. And then over the page, the beneficiary is blank. So Pleshakov could have stuck his name in there, appointed to himself, and that's certainly a power that was available to him. And as I say, the question the board and the learned judge asked himself was, why on earth did the respondents produce this document and provide it to Pleshakov? And we say, given what this enabled him to do, that it could only have been because the respondents believe that Pleshakov was a true beneficial owner of the SkyStream shares and wanted to give him a document that they thought would help him to establish control over SkyStream if he needed to. And that is precisely the conclusion that Justice Bannister arrived at in paragraph 56 of his judgment, when he said, and I quote, that the trust deed is, I quote now, is compelling evidence that it was the intention of the respondents that SkyStream was to be and remain under the control of Pleshakov. That's the judge's finding. The respondents, by contrast, do not have and have never had a coherent explanation as to why they went to the trouble of producing this document, giving it to Pleshakov, if it wasn't to recognise his ownership of SkyStream. Their pleaded case is at page 111. I'm running short, so I won't take the board to it. It says this: the deed of trust was intended only to allow the claimant for a period of 5 years as a matter of Russian law to act on behalf of the company in the event of his power of attorney expiring after 3 years before a new power of attorney was in place. We suggest that is just nonsense. We've seen the term of the deed of trust. It was 50 years or such short a period of time as Pleshakov should determine. But in any event, there was no reason why any power of attorney, and there was a power of attorney, could not have been extended. And no reason why the power of attorney couldn't have been for 5 years, 10 years, 15 years in the first place. In fact, so hopeless was their evidence on it, their case on this, that they didn't pursue it in evidence. They then came up with an argument that it was somehow necessary to enable Mr. Pleshakov to open a depository account in Russia. The learned judge rejected that in paragraphs 57 and 58 of the judgment for the reasons he gives there, not appealed. And the Court of Appeal just did not engage with this analysis. So that's an important point, the deed of trust. Again, why were the share certificates provided to Mr. Pleshakov? That's an analysis that the learned judge engaged in. It's not an analysis that the Court of Appeal comes up with they poo-pah it, saying that they're not evident, they're not titled, they are not the shares. Well, Justice Bannister himself made that point. We know they're not the shares, they're not bearer shares. The question is, why was all this done?
Well, Mr. Levy, we're coming to the end of the short break.
I do apologise. That is a convenient moment. I'll liaise with my learned junior. There's just a couple more documents I'd like to take the board to, if I may.
Yes, well, we'll stop now. We'll resume in 5 minutes' time.
Well, yes, thank you. I'm going to leave my room and speak to Mr. Warrant, if I may.
Yeah, well, if you turn off your video, you won't be, as it were, on screen while you do so, but don't turn off the whole transmission.
You're making certain assumptions there about my abilities. It's very kind, but you're wrong.
Please continue, Mr. Levy.
I'm obliged, my lord. My lord, if I do go over by 5 minutes or so, I'll just cut it off my reply if that's acceptable to the board.
It is, but you need to bear in mind that your reply is very short anyway.
Very short. Yeah. My lord, the share certificates do have a read. Well, but the court will have seen how Mr. Justice Bannister dealt with these in paragraph 58 of the judgment. But as he rightly pointed out, as long as Mr. Pleshakov retained the original share certificates, it placed considerable practical difficulties in the way of the respondents if they wanted to transfer the shares to anybody else. Any purchaser or whatever, pledge trustee, any purchaser, mortgagee, pledgee would want the original share certificates. So simply to say that they are not the property, the shares are the shares, and the share certificates are really evidence of ownership is really nothing to the point. And the conclusion that Justice Bannister drew from that, in paragraph 59 of the judgment, was that the most natural explanation as to why the certificates were placed in Pleshakov's permanent custody is that the respondents believed him to be beneficially entitled to the shares that they represented. And that's an entirely proper, sensible, credible, evidence-based conclusion for a trial judge to have reached. And it's not the kind of conclusion that an appellate court should interfere with. True enough, if any of my lady or my lords had heard this case, they may have come up with any number of different answers. But that's not the point, and that's not the test. So, Lord, can I just go very briefly to the acquisition of the SkyStream shares? The final piece of the jigsaw is the acquisition of the 20% stake in March 2006. And for that, can we look at page 1594, please? So that is a resolution of SkyStream. And if we look at the second paragraph, it's unanimously resolved to give the Commission and appoint Pleshakov to hold negotiations and to buy at the expense of, for and on behalf of SkyStream, up to 20% of the issued and outstanding ordinary shares of JSC Transaero, and to provide the seal and whatever else. We suggest that's a pretty extraordinary document in this context. If Messrs. Linkov and Kazantseva want to say that they are the beneficial owner of SkyStream, it gave, save in relation to the quantity of shares, it gave an unlimited mandate to Pleshakov to agree, I don't say whatever he wanted, but to have agreed any terms. Price, generally speaking, is a driving factor in commercial negotiations. They gave him, at a time that they didn't know the cost of the shares, the price at which the bargain would be struck, an unlimited mandate to agree anything. Not only that, it was not subject to any form of oversight or reporting obligation, and there was no suggestion in the evidence or in the documentary record that there was any sort of reporting back or oversight. It is not, we suggest, credible, and this supports the learned judge's judgment. It is not credible to say that SkyStream would have just said, well, here you go, Mr. Pleshakov, go off and do your best. If it's 55,000, if it's 55 million, doesn't make a difference, just sign us up. It's not consistent with an arm's length commercial transaction. And then Pleshakov goes off, and of course he does negotiate a 19.9% stake. From my Lord's notes, it's the sale and purchase agreement is at page 1635. In the interest of time, I'm not going to take the tribunal to it, but the price is $55,000, and the document was signed by Pleshakov using his power of attorney. Now, in the Court of Appeal, the respondents have made a bit of a hoo-ha about how Linkov apparently provided the £55,000 from his own bank account. And it's fair to say we didn't provide any evidence to say that we gave him that particular £55,000. But we've already seen that the learned judge found that there were complex financial arrangements between these people, cashed fill envelopes, and the fact that the respondents have received substantial amounts of money. And you've seen what we say in our written case about it. But as I said, in relation to the $1,000, which is relatively small beer, which is small beer, as is the $55,000 in context, that is not the deciding factor. And as the judge found, if he hasn't been compensated, if he is a bear trustee, if Mr. Linkov is a bear trustee, and he hasn't been repaid his £55,000, dollars rather, he's entitled to an indemnity. but then we've got cash-filled envelopes. And Mr. Warrants will make good the point that we've seen in transactions subsequent to this that small percentages of these shares that SkyStream acquired were transacted for millions and millions of dollars. Furthermore, if this transaction in favour of Linkov and Kazantseva was some form of disguised remuneration for work done previously for Transaero for which they weren't paid, then why have anything? Why have any consideration? Why not just give them to them? Doesn't make sense. The answer that does make sense is that this was dressing up, and I use that word in a non-pejorative sense. This was creating a transaction whereby Pleshakov was acquiring an interest in the shares under the guise of a normal transaction. But it's certainly not consistent with delayed remuneration for work done previously. And it's entirely consistent with Pleshakov's case. It's entirely consistent with Pleshakov's case that he wanted to, and the pleaded case, that the obligation to offer to buy out would not be triggered if the transaction went ahead in this way. Now, a great deal of fuss is made about whether Pleshakov actually owned the Transaero shares before they were transferred to SkyStream. And his evidence on that when he was cross-examined wasn't particularly clear. But his case was that he didn't own them. And of course, his case theory, and it's right, is that he couldn't have owned them, because if he did own them in that Russian sense, or the sense known by Russian law, he would have had to have made an offer. But his point was, I negotiated it. I agreed the terms, and I could direct where it went, where the Transaero stake went. And that, we say, is a significant pointer in relation to beneficial ownership. It was never an essential part of his case that he did actually own them. And in fact, it would have been at odds with his case that he did own them before the transfer to SkyStream. Now, on this point, and I'll probably close with this, the respondents rely very heavily on paragraph 12 of the learned judge's judgment, which is at page page 4. At trial, Mr. Pleshakov's case boiled down to its essentials was that the Transaero shares obtained by SkyStream on 31st of March 2008 belonged to him beneficially. He would never have agreed to give 20% of Transaero to the defendants via SkyStream, because that would have destroyed his majority. That being said, it was only natural that SkyStream should also belong to him, and the opposite of natural, that the company holding the shares should belong to third parties. The respondents rely very heavily on that as amounting to a finding that Pleshakov's case depended on him proving that he owned the shares beneficially before they reached SkyStream. But we say that in context, it's clear that the judge is referring to the position after the Transaero shares had been received by SkyStream. And it chimes with that, because at that stage, Pleshakov did become the ultimate beneficial owner on a look-through basis. If he was the beneficial owner of SkyStream on a look-through basis, he was the beneficial owner and controller of that stake in Transaero. At worst, that passage of the judgment is ambiguous. If the judge had really thought it was essential to Pleshakov's case to establish prior beneficial ownership of the Transaero shares, he would have addressed it. He was an experienced judge. That he didn't do so was because it wasn't an essential part of his case. His case was that he had the opportunity to control the destination of the shares, and that's how the case was put in oral closing. And for your notes, it's pages 1076 to 1078. So that concludes my submissions on the circumstances leading up to incorporation. I'll now hand over to Mr. Warrants to deal with events after the acquisition of those shares. Unless there's anything, of course, I can assist my ladies with.
Well, Mr. Warrants, you may have to do it at a gallop rather than just at a canter.
I was going to say, my lady, my lords, I hope you will forgive me for taking this at pace. Of course, if there are any points along the way on which I can assist any members of the board, please do let me know and I will slow down that pace accordingly. As Mr. Levy said at the outset, what I'm going to address, my lady and my lords, on is the judge's findings about the subsequent events between the acquisition of the Transaero shares in March 2006 and the commencement of these proceedings in 2013. Before I do so, I just want to be clear about the basis on which we say the evidence about these subsequent events is relevant at all. I want to be clear that we don't suggest that anything that happened after March 2006, or frankly anything that happened after December 2005, actually created a trust over the SkyStream shares. What the subsequent conduct goes to, we say quite properly, is the judge's assessment of the credibility of the witnesses as to their differing accounts as to what was intended at the time when SkyStream was incorporated. And we say the judge had it absolutely right when he said at paragraph 52 of the judgment that while I accept that the whole of the party's conduct in any given case may be capable of throwing light upon the arrangements under which property has been acquired, it will, in my judgment, be the circumstances surrounding its acquisition which will have the most bearing upon the resolution of that question. Now, this is fully consistent with the case law on the relevance of subsequent events in disputes of this kind. I'm not going to turn up the authority, but you will see that we've extracted at paragraph 128 of our case, which you can find at 2293, a passage from the judgment of Lady Justice Smith in the decision of the English Court of Appeal in Maggs and Marsh, where she held, in the context of a dispute in that case about the existence of an oral contract, when talking about the accuracy of those recollections may be tested and elucidated by things said and done by the parties or witnesses after the agreement has been concluded. Receiving evidence of such words or actions does not mean that the judge is losing sight of his task or deciding what the parties agreed at the time of the contract. It is simply helping him to decide whose recollection is right. And we say that in principle, mutatis mutandis, the same approach applies where there is a dispute about the existence of a trust which has not been recorded exhaustively in a written instrument, which is this case. So we say the judge was fully entitled to look at subsequent conduct of the parties to help him decide whose evidence was right about what was intended when SkyStream was incorporated. Now, obviously, if the parties behave in a manner which is fully consistent with the respondents believing that the SkyStream shares belong beneficially to Mr. Pleshakov, and inconsistent with the respondents believing themselves to be the beneficial owners of the SkyStream shares, then those are proper matters, we say, for the judge to take into account in deciding that the shares were held on trust for Mr. Pleshakov from the outset. And we say that's exactly what the judge did in this case. And that's what he meant when he said at paragraph 62 of his judgment, that in my judgment, the evidence establishes that the defendants acquired the SkyStream shares as nominees for Mr. Pleshakov. And he went on to say, nothing that happened subsequent to that acquisition is inconsistent with that finding. Indeed, it fully harmonizes with it. Now, the weight to be given to these matters was, of course, a matter primarily for the trial judge. The judge rightly considered that the evidence going directly to the events at the end of 2005 and in the immediate aftermath of the incorporation of SkyStream were the most important evidence. But he was fully entitled to and did check his conclusions in relation to that evidence against the subsequent conduct of the parties. And if you look at the judgment, we say you can see that the learned judge relied on 6 elements of subsequent conduct to support his conclusion. First, the fact that the respondents invariably followed Mr. Pleshakov's instructions when voting the Transaero shares over the years, and specifically that they considered that Mr. Pleshakov was entitled to instruct them to do so. Secondly, the fact that Mr. Pleshakov made all the decisions about the subsequent sales and purchases of tranches of Transaero shares by SkyStream. Third, the payments received by the respondents over the years, which is consistent with the respondents being paid by Mr. Pleshakov for acting as his trustees. Fourth, the amendment to SkyStream's Articles of Association in 2010 to provide for, I think it's 1.2 million euros each to be paid to any director removed from the board of SkyStream. Fifth, Mr. Linkov's conduct in relation to the acquisition of an apartment in Miami for Mr. Pleshakov's benefit through a wholly owned subsidiary of SkyStream, in which he repeatedly referred in contemporaneous correspondence to Mr. Pleshakov as being the owner of that apartment. And sixth, Mr. Linkov's conduct in 2013 when the relationship between the parties broke down, when Mr. Linkov repeatedly made statements indicating that he recognised Mr. Pleshakov's ownership of the assets. Now, I'm going to briefly expand on those points to show you how the judge dealt with them, we say impeccably, and how the Court of Appeal just didn't properly engage with the judge's reasoning, which is a common theme, a problem with the Court of Appeal's approach in general. But as a preliminary point, I would just say on this question of weight, that the Court of Appeal was totally dismissive of these points about subsequent events. They went so far as to say at paragraph 3 of their judgment that, quote, the points made by Mr. Pleshakov relating to conduct years after the event are far narrower and less telling than the points of the respondents. Then in the last sentence of paragraph 54, it's said by the Court of Appeal that subsequent conduct is, quote, at its highest relied upon as points of consistency in respect of conduct years after the acquisition, which has very little probative value. So essentially we say in the light of that, the Court of Appeal effectively treated those matters as having very little or indeed no weight whatsoever. And in my submission, the Court of Appeal was not justified in taking that approach, not least because it's not appropriate, in my submission, for an appellate court to interfere with the judge's weighing of the evidence before him. Certainly, it wasn't appropriate to entirely discount matters relating to the subsequent conduct, which the judge properly found reinforced his view that the respondents had always intended to hold the SkyStream shares on trust for Mr. Pleshakov. So turning to the first of the 6 matters, I mentioned that the respondents always caused SkyStream to vote the Transaero shares in accordance with Mr. Pleshakov's directions. Now, the judge dealt with this at paragraph 51 of the judgment by holding that, quote, another issue that arose generally during the evidence was the matter of Mr. Linkov's voting of SkyStream's Transaero shares at general meetings of Transaero. It was the evidence of Mr. Pleshakov that he gave instructions to Mr. Linkov how he was to vote the shares. Mr. Linkov accepted that he discussed voting with Mr. Pleshakov, who offered proposals on the subject, and went on to say that he always supported Mr. Pleshakov at general meetings of Transaero. Ms. Simonova said that she provided Mr. Linkov with instructions how the shares were to be voted, and that those instructions were invariably followed. I accept Ms. Simonova's evidence on this point, which is consistent with the closing words of Mr. Linkov's email of 9th of September 2010. In different circumstances, I would take you to the email of 9th of September 2010, but I'll give you the reference in a moment and make some comments on it. And I very much hope that my lady and my lords will have an opportunity to look at that document in due course. But the point I want to make about the judge's analysis is he isn't just deciding that the respondents happened to align their votes when acting as SkyStream's directors to vote the Transaero shares alongside Mr. Pleshakov. The specific conflict of evidence which the judge was resolving was whether Mr. Pleshakov was giving what might appear to be mandatory directions, which the respondents believed that they ought to obey because they knew that Mr. Pleshakov was the ultimate beneficial owner of SkyStream, or whether, as the respondents seemed to say, Mr. Pleshakov was just giving friendly suggestions, which the respondents were free to disregard if they saw fit. Now, what the judge did is he accepted the evidence of Mr. Pleshakov and Ms. Simonova on this point, and he found that Mr. Pleshakov was giving instructions rather than mere suggestions. and he rejected Mr. Linkov's evidence to the contrary. And we say that is a classic situation. The judge has heard rival accounts from the witnesses who give evidence, and he has to decide which witnesses to believe. It's exactly the kind of factual finding which really ought never to be overturned by an appellate court. And we say there is, as the judge found, contemporaneous documentary evidence to support the judge's analysis and conclusions on this point. And that is the email exchange on the 9th of September 2010. For my lady and my lord's note, you can find that at the foot of page 2167, over the page onto 2168. The first email, I'll just describe it now, is one in which Mr. Pleshakov gives a series of clear instructions to Mr. Linkov relating to matters concerning SkyStream. And to paraphrase, Mr. Linkov writes back and says he'll do exactly what Mr. Linkov has asked him to do. He says in one part of that email that he will prepare fees and expenditure reports once a quarter. And then he goes on to say that all your instructions will be rigorously performed, but please give me a right to worry. So you have a completely supine Mr. Linkov acting and agreeing to act in accordance with Mr. Pleshakov's directions, mandatory directions, as to how SkyStream was to be managed. And we say that email clearly supports the judge's finding that Mr. Pleshakov was giving such binding instructions. And the Court of Appeal just ignored this analysis. It didn't address it at all. The only comment on this issue made by the Court of Appeal is at paragraph 54, where it stated that the fact that Mr. Linkov voted alongside Mr. Pleshakov in respect of the Transaero shares is consistent with collaboration between two persons who in any case work closely together. Now, on one view, that's an interpretation of the evidence a trial judge could come to. But the point here is that the judge went beyond that. He made an assessment of the rival competing evidence of the witnesses at trial, and he came to a firm conclusion that what were being given were not suggestions, but mandatory directions. So those statements from the Court of Appeal just talk past the judge's factual findings.
Mr. Warren, don't forget that you are 2 minutes away from being on borrowed time.
My Lord, I propose to take till, I think, 25 to, and we'll take 5 minutes off our reply time of 15 minutes, if that's acceptable.
It's going to have to be a strict allocation because Ms. Doman must have her full and fair allocation in response.
I fully understand, my Lord, and I will work to that timetable. So with the greatest of respect to the Court of Appeal, that finding can't be ignored, and the events recharacterised by the Appellate Court without engaging in the factual dispute which the judge determined. And it wasn't properly open, we say, to the Court of Appeal to just decide to give those matters no weight at all. So then we come to the sales and purchases of the Transaero shares. And I don't think it can be in dispute at this point that there were 7 such transactions, and the judge found as a fact at paragraph 24 of the judgment that not a single one of those transactions was arranged by either of the respondents. They were all arranged by Mr. Pleshakov. And the judge also made a factual finding at paragraph 26 that the respondents had never refused to carry out a transaction proposed by Mr. Pleshakov, again rejecting the respondents' evidence. In different circumstances, I would take you to the table that follows our written case at page 2311, where we set out the details of those transactions. There isn't time to do it. I will summarise the points I would have made. They're largely covered in our written case in any event. But the point to draw from it is one can see from those transactions, particularly the ones that occur in the months after the shares were originally acquired by SkyStream, that those shares are being traded at a level which is out of all proportion to the $55,000 nominal consideration which was paid in the first place. And if it is said, as I think I understand my learned friend to say, that some of these transactions are with the Pleshakov family, and that might explain why the values are proportionately so high, in my submission, that in fact simply bolsters Mr. Pleshakov's case. Because if favourable deals were being done with the Pleshakov family, that rather suggests that, in fact, it's Mr. Pleshakov who's pulling the strings and the one who has a real interest in this company. So whichever way you look at these transactions and whichever way you look at the value, we say it demonstrates and supports Mr. Pleshakov's case and undermines the respondent's case. But there's one particular transaction that I want to pick up on, which the judge mentioned, which is a transaction that Mr. Pleshakov did without any knowledge, apparently, of the respondents, which was to transfer a stake, a 1% stake in Transaero to an associate, Mr. Terashenko, for $20,000, which the judge found as a fact were then sold on by Mr. Terashenko for more than $5 million. Now, what this demonstrates is that the respondents, again, were completely supine. On their case, this was a fraudulent misappropriation of their assets, and yet they do not complain about it. The most that the respondents can say is that after that, Mr. Pleshakov always got a board resolution to support further trading with the shares. But again, the judge's clear finding was that all of these transactions were still being done by Mr. Pleshakov and being decided upon by him rather than by the respondents. So in the light of that, again, the point I would make about the value is it throws into sharp relief that this $55,000 payment that the respondents rely so heavily on to establish their own beneficial ownership of SkyStream simply doesn't stand any comparison to the true value of the transaction that is going on. And in my submission, it's just unreal to point to that $55,000 payment and say that that proves that, in fact, the respondents own SkyStream. Moving to the third topic, the payments received by the respondents. And I should say, if I do go past 25.2, any further time will come off the reply.
Well, no, Mr. Warrants, it isn't a right to overspend.
Yes.
If you overspend, it will come off reply, but you still have to have our permission to overspend.
Yes.
So I think you should take it that we will want to be hearing from Ms. Doman from 25.2 onwards.
In that case, I will make my points incredibly briefly, my lord.
Please.
Payments received by the respondents. One has the judge's clear findings that they are cash-filled envelopes, no right for the Court of Appeal to overturn that, no dispute that payments of €4,000 per month were received by Ms. Kazantseva, again, entirely consistent with the case advanced by Mr. Pleshakov and contrary to the case of the respondents. The next point is the amendment to SkyStream's Articles of Association, not engaged with by the Court of Appeal at all. The judge correctly found that there would be absolutely no reason whatsoever to make an amendment to the SkyStream Articles of Association to provide benefits to directors who resign if the respondents were themselves or considered themselves to be the beneficial owners of SkyStream. In those circumstances, it's quite staggering in my submission. The Court of Appeal didn't engage with that because it's a very compelling piece of evidence which points clearly to the correctness of the judge's conclusion that the respondents cannot be the beneficial owners. Then we have the Miami apartment. In short, the point here is that the property is being purchased through a wholly owned subsidiary of SkyStream. Mr. Linkov consistently refers in contemporaneous documents to Mr. Pleshakov being the owner of that apartment. Mr. Linkov's evidence that there was an agreement to sell on the apartment for a 10% increase was rejected by the trial judge. There's no appeal against that, and therefore the respondents cannot explain why Mr. Linkov was behaving in that way, other than an acceptance that Mr. Pleshakov was the beneficial owner of both Sky Ocean and the apartment, and ultimately of SkyStream. Lastly, we have the events in 2013, and we're on the home straight here. Essentially, what you have is the relationship breakdown. The judge, again, clearly finds in favour of Mr. Pleshakov and rejects Mr. Linkov's evidence. Mr. Linkov's evidence at trial is that he was threatened at a couple of meetings in 2013, and that's why he signed various documents and wrote various emails appearing to recognise Mr. Pleshakov's right to own and control SkyStream. Since that evidence that he was threatened was rejected, and there's been no appeal against that, Mr. Linkov simply has no explanation for his conduct other than that in truth he recognised that Mr. Pleshakov was the sole beneficial owner of SkyStream. That brings me very last, with 10 seconds if I may, my lord, to say that in those circumstances the Court of Appeal's reasoning is entirely unjustified, and that the judge's reasoning should be upheld, and for the reasons set out in the written case, which I rely on otherwise, those are my submissions.
Thank you. Ms. Doman.
My lord, my lady, my lords, thank you very much. I'm very grateful that I'm reached after all of that. The position is much simpler then appears to have been developed here. Mr. Levy said, even if there was no contract, it is a proprietary claim, and that is the end of it. The problem is, how does the proprietary claim arise? What is the genesis of it? And at first instance, and still at Court of Appeal level, the genesis of the proprietary claim was the oral agreement. It simply wasn't anything else at any stage at all until we came before the board. And it is that oral agreement that was a main plank, building block, as the Court of Appeal saw, of the claimant's, Mr. Pleshakov's case. He agreed with Mr. Linkov that Mr. Linkov would do a whole series of things, and he would give him consideration. Indeed, he would pay Mr. Linkov and Ms. Kazantseva €4,000 directly himself every month. And he would give them instructions that they would comply with. And he sent them to the British Virgin Islands, and everything was at his instructions. And you see, this failed. It absolutely failed. He did not send them to the British Virgin Islands. He did not fund their claim. He did not pay the incorporation fees. He did not acquire the shares. The shares are registered in the names of the respondents. They are the registered shareholders. They bear no burden of proof. And Mr. Levy has rightly accepted that the burden does not and did not shift. The burden of proof is plainly, squarely, entirely on Mr. Pleshakov as to how his proprietary claim arises. What is the genesis now? What is it? We still don't know. I will come to that in the context of making submissions on bare trust. But what Mr. Pleshakov plainly seeks to do is to say, on the one hand, this is a bare trust. Everybody knows what that means. It can arise in all kinds of different circumstances. But here, the bare trustees had massive obligations of organization, administrations, transactions, everything else. This was not a holding company, Mr. Pleshakov was keen to emphasize. It is a company that was a vehicle for lots and lots of transactions and loads of things that needed to be done, in which, by the way, he took no interest when it came to any reports, to any accounts. He never saw the financial accounts. He never asked about any monies. He never asked about any dividends. It was all the matter for the registered shareholders and board directors who were the respondents. That was the main building block first, the oral agreement. Now described as irrelevant, and you can forget about it. The second very important building block was the ownership, the prior ownership, beneficial ownership of the Transaero shares. That was a huge part, not of our case, of Mr. Pleshakov's case. He was adamantine that he previously was the owner, that these shares were his property. And one can see why he would have made this case, because one can readily see that if somebody does have beneficial ownership in particular property, then if he wants to keep it, he will set up a structure where that beneficial ownership is preserved. That makes complete sense. And for that reason, no doubt, Mr. Pleshakov emphasized throughout how he acquired the shares, he owned them, and he said in terms, in oral evidence, Ms. Kazantseva, Mr. Linkov knew they were my property. Now, my lord, we deal with this first principal plank about ownership of the Transaero shares in our written case at page 2324 to 7. But might I go first to the written case of Mr. Pleshakov, paragraph 118, where Mr. Levy again submitted this morning that the judge in his paragraph 12 was referring to the situation after the Transaero shares were transferred from Housecroft to Skystream. But the judge was not referring to that at all. Not least because, and that was paragraph 118 of the Pleshakov's written case judgment at page 4, paragraph 12. One cannot destroy a majority interest by effecting a transfer of shares unless a majority interest existed prior to the transfer. That is not what the learned judge said or held that Mr. Pleshakov owned the Transaero shares. And he did rightly say in his judgment that when you boil down Mr. Pleshakov's case, it boiled down to, yes, he was a beneficial owner of the Transaero share. In the written case of Mr. Pleshakov at paragraph 115, page 2288, it is stated, quote, it was never Mr. Pleshakov's case that he had already acquired ultimate beneficial ownership of the Transaero shares before they were transferred to Skystream. It was, as I've already said, strenuously so. And if you look at the examples we cite, they are set out at page 2324, at paragraph 26 of our written case. And for ease of reference, we have set them out there so that the board should not need to turn up all the examples. But you see at paragraph 26, the reference I have already given in the pleadings and in the written evidence, where it was said at the time when the Transaero shares were transferred to Skystream, they were, and Mr. Linkov and Ms. Kazantseva knew them to be, my property. Now, how on earth can it even be argued that that was not a vital plank of Mr. Pleshakov's case? It absolutely was. And then you have other examples that we set out.
I'm so sorry. Does it not
Yes.
depend on what you mean by saying something's your property? If you control something, you would perhaps say it's my property. And the recital A to the trust deed made it clear that he was to control property.
Well, my lady, I will, of course, address the trust deed and that recital. That is something we will address in the context of trust deed. It refers to the share certificates, which, of course, give no rights and no ownership rights or other rights. They are just evidence of the shares, and they are not themselves a trust property.
But Mr. Chairman, are we not getting into a slight angle? The trust deed is about the Skystream shares, is it not? Whereas you're talking about the Transaero shares.
I am indeed, my lord, yes.
Thank you.
I was hoping to answer my lady's, of course, very important point on the schedule in the trust deed. But now, at this moment, I'm dealing with the Transaero shares. And where Mr. Pleshakov said they were my property, the point is put to me that you might refer as something as my property because you can control it. In my very respectful submission, Mr. Pleshakov wasn't talking about I could control it in this context. He was talking about my property and my beneficial interest. And he puts both points when I quote next in the last 3 lines at page 2324. In March 2006, I acquired the entirety of the Transaero shareholding for the Brevi Group, which amounted to, and you see the percentage, 43.15. I therefore gained ownership and effective control, so it's ownership and effective control, of nearly 88% of the issued shares. And then he says he instructed Mr. Linkov to make necessary arrangement to incorporate the SPV for the sole purpose of holding some of BB Group shares, which I was about to purchase. And then we have paragraph 27, where Mr. Pleshakov accepted in his oral evidence that the Transaero shares were owned legally and beneficially by Housecroft. And that was the true position. So I don't give you all the other references given time constraints, but it is important to remember that this was the case at first instance, but it was not anymore at Court of Appeal level. At Court of Appeal level, it was said that the beneficial ownership by Mr. Pleshakov of the Transaero shares were a red herring. And the quality of red herring is still the position now before the board. So once the case came before the Court of Appeal was in a position where the oral agreement plank still existed, but the beneficial ownership of Transaero no longer did. My lord, my lady, I come briefly to the value of the Transaero shares. And we deal with that in our written case at page 2364 to 2366, paragraph 124 to 7. Now, Mr. Pleshakov's written case in various instances which I can cite presses, and in oral submissions as well, the implausibility, given the value of those Transaero shares, that Mr. Pleshakov would direct them to SkyStream. The true value is said to be so much higher. Indeed, the written case says at paragraph 3, probably more than 50 million. And they were extremely valuable. They may have been worth 100 million, we see at paragraph 122 of the written case. And as we heard again this morning, there was a vast disparity between $55,000, which were paid by Mr. Linkov, and the true value. There is, however, no true value in this case, and none has been established. One needs to remember at all times looking at this, that what we have by way of date for the acquisition by SkyStream of the Transaero shares from Housecroft is March 2006. That's the date. Now, at trial, Mr. Pleshakov had 8 witnesses. He had every ability to produce documentary evidence, and he had endless resources so to do. He had the burden of proof on every positive point. He chose very deliberately not to do that. He produced no document and no witness to have anything to do with the so-called true value of Transaero shares. There was, of course, no expert valuation. And he chose not to disclose the price paid by Housecroft to the BB Group. The acquisition price by Housecroft was not disclosed. The judge quite rightly made no finding, nor could he have done, on that so-called true value. We set out at paragraph 126 of our written case, firstly, at 126.1, the nominal value of the SkyStream shares was 0.036 pence, and it was $11,071 for the total that was acquired. These were never quoted shares, and there was no market price. The bond issue has been mentioned. Mr. Pleshakov wrongly said that the bond issue was to help the acquisition from the BB Group to purchase the shares. In fact, the bond issue was made to expand the aircraft fleet. My lord, we have the bond issue at page 1525. The printout is complete, very, very poor indeed. But I give you the reference. The main points to be taken from the bond issues are that it is very clear, and it's stated in terms, that the equity of the company had negative value. Negative value. And it is explained that the negative value had to do with currencies and with the difficulty acquiring aircraft and the cost and so on and so forth. It's a very lengthy document, but one cannot get away from the negative value. Now, the transaction, the 7 transactions that are relied on with our family, friends, associates, and they cannot begin to prove a bona fide market price, a so-called true value of these shares. They are plainly wider transactions. The first one that deals with the purchase price paid to SkyStream of $20,000 and that packet of shares then being sold on for 5 million. Well, it went actually to Transero Finance, and it was clearly a much wider transaction. We don't know what repayment of loans or other transactions are behind it. Why? Because we saw no documents about this. And I do submit that you cannot properly preanate a transaction where you say, here is $20,000, here is 5 million, look what the true value is, without producing the documents underlying the 5 million transaction. That evidence was deliberately not produced. And the proper inference is that such documentation would not have supported Mr. Pleshakov's assertion. And I respectfully refer to the decision of my Lady Arden in Mumtaz, and I don't turn up the authority, given the difficulties, but it is at 99 in the authorities bundle at page 40. And I will have to give you the page reference. I will do. Yes. What's the page reference? 3582. Thank you very much. Thank you. I apologize. Now, I come to the question of the bare trust and the need to establish intention. You haven't got a nominee agreement in front of you, and no oral agreement has been established. Somehow, there has to be the trust coming to life. And we deal with that in our written case at section D, paragraphs 81 to 90, page 2349 to 51. Now, the nature of the requisite intention on the part of the settlors is set out in Snell at paragraph 22.013. We set it out in our written case at paragraph 82, page 2349. And that intention evidently has to be the intention of each of the settlors and of each of the bare trustees. in his case, written case, Mr. Pleshakov, at paragraph 25, page 2267, tries to cover all requisite intentions by alleging that Mr. Linkoff and Ms. Kazantseva, quote, intended to acquire the SkyStream shares as nominees for Mr. Pleshakov. This is a very fair allegation indeed, and it calls for a nominee agreement or something else. What?
I'm not sure who is the settlor on this basis.
My lady, yes, indeed, quite right. In this case, on Mr. Pleshakov's case, the respondents are both the settlors and the trustees, as I understand their case.
Yeah.
They're both. Because they're meant to hold the shares in SkyStream on trust for Mr. Pleshakov, who is meant to be the beneficial owner. So that makes them trustees. At the same time, presumably, they are the settlors because who else is?
Well, if he had the property in the shares, in the sense of right to control, which is certainly part of the beneficial interest, he might have been the settlor himself. In
the case of the Transaero shares, one could see that, but that isn't the relevant shareholding. Here we're talking about the SkyStream shares. The oddity, my lady, yes, my lady, it is a point that has troubled very much the first instance judge, because after all I was there, and the Court of Appeal. And the first instance judge, Justice Bannister, said, well, the Transaero shares, yes, but it's the SkyStream shares, not the Transaero shares. But we were really talking about the Transaero shares the whole time. That's what it was about. And I will come to the position at the end of the relationship between these parties when that relationship breaks down. When Mr. Pleshakov asks for the transfer, not of the SkyStream shares, where it is now said he is the beneficial owner. No, not at all. He doesn't even mention them. He doesn't discuss them. And the judge makes that finding. He asks for the transfer of the Transaero shares, which were always the only thing that were his real concern.
Well, that's not quite right, because other assets were put into SkyStream.
My lord,
we haven't got the accounts, we don't know. But there's some assets.
There are other assets as follows. The other asset that Mr. Pleshakov was interested in, come the breakdown of the relationship in the meeting in Munich, were the shares in SkyOcean. SkyOcean was the company that owned a flat in Miami. And Mr. Pleshakov was concerned to obtain a transfer of the Transaero shares, as I have already said, and of the SkyOcean shares, as I've already said. What he did not ask for at any stage ever until these proceedings happened was a transfer of the SkyStream shares. Now, if that is a convenient moment, my lady, my lords, may I then pick up precisely from this point at 2 o'clock, and I will do my best to get through what is quite a bit of material in quick time.
Yes, indeed, Mr. Eamon, and you'll get an extra 5 minutes at the end.
Thank you so much. Thank you.
The court's adjourned until 2 o'clock.